We're now going to talk about a type of remedy that you can get that's beyond the value of a contract or the value of the property or personal injury damage that was suffered. Similar to loss opportunity, which is also a loss beyond value calculation, we have loss of use. And in the Fukita case, the underlying cause of action is actually trespass to channels, which is trespass to Fukita's car. And we're switching gears a little bit because we've been talking about contracts this whole time, but now we're using torts as an example. In this case, Fukita is seeking the remedy of one, return of his actual vehicle, two, special damages for the cost of renting an automobile while the repair shop retained his vehicle. And remember, special damages are quantifiable, they can be measured, unlike pain and suffering, that's a little bit more fluffy, so it's the general damage. And then three, attorney fees and costs. I want to pause real quick just to talk about equitable replevin, which is an in personam order enforced by the court, enforced by contempt, right, or the court. And it's essentially a remedy for trespass to channel specifically, where the plaintiff gets the property back. A little bit different than legal replevin, where it's is accomplished by the order of the sheriff. So the sheriff actually goes to get it back versus the court having this order that you need to give it back or you'll be held in contempt. And the big question everyone has is, well, is replevin a legal or equitable remedy? And it's kind of confusing, and scholars debate about where it belongs in the great chart of remedies, because it's technically equitable because you get the property back. You're not getting any money, you're getting the actual action. But it's also legal because you can collect loss of use damages for the property when it was in the hands of defendants, which is money damages. And so for purposes of this class, we've slotted it in the legal remedies section because we're talking about it in the context of loss of use damages. But do remember that it could appear as, equitable in some supplements or other papers you see because of the whole enforced by contempt in personam aspect of replevin. But our focus again is loss of use. And in this case, we had a counterclaim where the defendant is seeking the cost of repair and storage fees for the amount of time that the defendant had to keep the car. Because what happened here was Fukata wanted to inspect the transmission before the installation. The repair shop was going to install this transmission, but the repair shop failed to actually contact him before installing as requested. And so after the car was repaired, Fukita refused to pay the store, and then the store refused to give him the vehicle back. And so now the store has retained possession of the vehicle for almost 2 years, from June 2nd, 1996 to August 29th, 1998. And this case was complicated because there's a lot of stuff going on procedurally, which is somewhat insignificant, but I wanted to make sure we clear this up before we get to the substantive rules. But the district court determined that the lien the repair store put on the plaintiff's car was unlawful because it didn't even comply with the request, where it agreed to call Fukita before it repaired the car by putting the transmission in. And so it dismissed the defendant's claim, said no storage, and said they must return the vehicle. It also awarded the loss of use damages of about $7,000, calculated as $10 a day for 2 years, right? Saying that's how much it would have cost for him to get a replacement vehicle. The appellate court reversed the loss of use award, but then the Supreme Court reversed the appellate court's decision and remanded it back to the appellate court. And on remand, the appellate court held that the damages for loss of use were excessive and stated that they're capped at the value of the vehicle. Because the whole issue was the car's value was only about $5,000, right? $4,900. But the loss of use value awarded by the district court was $6,970, almost $7,000. And so it doesn't make sense in the appellate court's mind that your loss of use is more than the actual value of the car. The Supreme Court reviewed it again, and it agreed that, yes, the plaintiff doesn't have to establish that he actually rented a vehicle to get these loss of use damages. But it reversed the appellate court's ruling that loss of use couldn't exceed the value of the car. The reasoning behind this was on page 599, where the court said the vehicle's value is a factor that bears no relation to the inconvenience that the loss of use of one's vehicle causes. So they're two separate things, where you have the actual harm to the car and then your inability to use the car, which are two separate harms. Essentially, what the Supreme Court has done, it's an done analysis of that two-step process we keep talking about related to legal damages, right? One, is loss of use appropriate in this situation? And two, how do you measure loss of use? And so let's break that down substantively so you could see the rules they use to make this decision. In step one, is P entitled to compensatory damages for loss of use? That was the first issue they dealt with. And the rule that you need to memorize is loss of use damages are awarded to compensate the plaintiff for the inconvenience caused by the inability to use his or her property, right? So it's a pretty general rule. But the court specifically talked about whether loss of use damages are available if a car is deemed a total loss and not repairable. And something is deemed a total loss when the value here, which is a loss of use, 7,000, exceeds the actual value of the car, which is only about 5,000. And the court answered yes. On page 598, paragraph 5, it said loss of use damages are available when the car is totally destroyed, as well as when the vehicle can be repaired. And the reasoning behind this is courts assume that a car can be replaced immediately if it's totally destroyed. But a car that's been completely destroyed, a person will still suffer an inconvenience during the reasonable period of time that it's necessary to obtain a replacement vehicle. So when a vehicle is being repaired, you have that time or that period where you get a rental car while it's in the shop, which is your loss of use of your car. But this also occurs when a car is totally destroyed. You still have to go out, go to the store, find a car, pick a car, go through all the paperwork, and then now you have a replacement vehicle. But there's still that period of time where you're losing the use of your car. So the court says there's no difference between total loss and a vehicle being repaired for loss of use damages. And what the court has actually said is technically you have two damages that you can collect for. One, the actual property damage to your vehicle, and two, the temporary loss of use. Property damage is measured by the cost to repair the vehicle or replace the damaged vehicle, or as we talked about in a past lecture, if that exceeds it, you just get the diminution value of the vehicle. Whatever the value to that property was, you get the property damage legal remedy. But now we have this temporary loss of use, which is a separate injury. It's a different injury. And this is what we call an injury that is lost beyond value. Because we're not actually looking at the value of the car. We don't care about the value of the car. We don't care about the value of your personal injury. We don't care about the value of the contract. We're just looking at what did you lose in terms of your use of this property. And so step number two is once you've determined that you get loss of use damages, how are these loss of use damages measured? Step number two, it actually showed up on page 590 to 591. I didn't have you read this case, but it's based on a car accident and it calculated the loss during the period of repair. So the rule to memorize for step number two is loss of use can be measured in three ways. One, the rental value or the amount that could have been realized by renting out the property, which again, you don't have to prove you actually rented it like we saw in the Fukita case, but that's how you can measure it. Two, the reasonable cost of renting a substitute, or three, the ordinary profits that could have been made from use of the property. And this loss of use applies to both personal property like a car, as well as real property such as a home or an apartment building.